There is no obligation to disclose an appraisal issue. Where a seller is demanding that buyer disclose the actual appraisal of the residence that the buyer paid for, is the buyer required to do so? Answer: no. The contract does not require the buyer to disclose the appraisal. The appraisal constitutes an opinion of value, which is addressed in Section 5B of the contract. A buyer has a duty to disclose to the seller all known facts materially affecting the transaction. Lombardo v. Albu, 1999 Arizar 97, 14 P. 3, 288, 2000. An appraisal is not a fact materially affecting the transaction, but rather an opinion of value. The subdivision addendum need not be used for the sale of a single parcel within a subdivision facts. The seller owns a single parcel of vacant land in a subdivision and wishes to sell this parcel. Issue: is the seller required to utilize the vacant land lot purchase contract addendum regarding subdivided or unsubdivided land, the subdivision addendum? Answer: no. The subdivision addendum is used to comply with the disclosure requirements of the subdivision laws and should be used where the seller has created or owns 6 or more fractional interests in land. Here, the seller does not own 6 or more fractional interests in the subdivision. Rather, the seller only owns a single parcel of land in the subdivision. As such, the subdivision addendum is not required. Note: the use of an AAR form by a party to a contract is not required in any event. Arizona Realtor or Magazine, January 2014. Disclosure: the seller must provide an affidavit of disclosure when the property is not subdivided in an unincorporated area. Facts: the seller owns a 36-acre parcel of land located in an unincorporated area of Maricopa County, Arizona. Issue: is the seller required to provide an affidavit of disclosure? Answer: yes. ARS, paragraph 33-422A, provides that a seller of 5 or fewer parcels of land, other than subdivided land, in an unincorporated area of a county must furnish a written affidavit of disclosure to the buyer at least 7 days before the transfer of the property, and the buyer shall acknowledge receipt. Simply put, a seller is required to provide an affidavit of disclosure in accordance with paragraph 33-422 if I. The seller is selling 5 or fewer parcels. I. The parcels are not subdivided land, and RSI. The parcels are located in an unincorporated area of the county. In this instance, the seller is selling a 36-acre parcel located in an unincorporated area of Maricopa County, Arizona. That being said, the only issue left to resolve is whether the parcel is subdivided. Pursuant to ARS, paragraph 32-2101-56A, subdivided land means improved or unimproved land, or lands divided or proposed to be divided for the purpose of sale or lease, whether immediate or future, into 6 or more lots, parcels, or fractional interests. In this case, the seller owns one 36-acre parcel that has not been divided into 6 or more lots or parcels. As such, the parcel is considered unsubdivided, and therefore an affidavit of disclosure is required. Note: effective August 27, 2019, the affidavit of disclosure includes disclosure of additional items: water adjudication and solar panels, pursuant to HB 2443 and HB 2485. The buyer's agent is obligated to disclose that the buyer does not have the required down payment facts. The buyer and seller entered into a contract for the sale of commercial property, which requires the seller to finance $1,000 pursuant to a seller carryback. The purchase price is $1,250,000. The buyer is required to put $250,000 down pursuant to the contract, but does not have the cash to do so. The buyer is therefore going to borrow money from a friend to fund the down payment. Issue: is the buyer's agent obligated to disclose that the buyer does not have the cash for the down payment? Answer: yes. Discussion: here, the seller is financing $1,000 for the buyer as part of the transaction. The buyer's financial wherewithal is therefore material to the transaction. See AAC R4 28-1101b, and Lombardo v. Albu, 1999 Arizar 99, 14p3d, 288, 2000. The buyer's agent is therefore obligated to disclose that the buyer does not have the $250,000 down payment. The bank, as the REO seller of the home, must comply with affidavit of disclosure and septic tank requirements issue. The bank has acquired a home in an unincorporated area of the county after the foreclosure sale. The bank now wants to sell the home as is, with no disclosure requirements and no certification of the septic tank. Is the bank exempt from the affidavit of disclosure requirement or the septic tank certification requirement? Answer: no. ARS. Par 33-422, requires that any seller of a home in an unincorporated area of the county furnish the written affidavit of disclosure at least 7 days before the transfer of the home. Although the trustee conveying the home to the bank by trustee's deed at the foreclosure sale is exempt from this requirement, the bank, after acquiring title to the home by trustee's deed, is not exempt when selling the home. Similarly, the bank is not exempt from AAC R18-9 A316, which requires certification of the septic tank within 6 months prior to transferring the home to a buyer. Termite damage discovered after the inspection period expired issue. In the seller's property disclosure statement, SPDS, the seller denied that the home had ever been treated for termites. After the inspection period expired, the buyer learned that the seller had the home treated for termites. The buyer no longer wants the home. After being contacted by the buyer, the seller admits that he forgot to disclose in the SPDS the prior termite treatment. Can the buyer cancel the contract and get the return of the earnest money? Answer: yes. Under Section 4F of the contract, the seller is required to update the SPDS to disclose the prior termite treatment. If the seller does not, the buyer is entitled to deliver a 3-day cure period notice to the seller demanding that the seller update the SPDS to disclose the prior termite treatment. If the seller does not update the SPDS within 3 days, the buyer can cancel the contract and get the return of the earnest money. If, however, the seller does update the SPDS and discloses the prior termite treatment, the buyer can cancel the contract within 5 days and get the return of the earnest money.